SJC-10304, Commonwealth versus Gomes.
Yes, good morning.
Good morning, Chief Justice Ireland. Good morning, Justices. Crystal Murray on behalf of John Gomes in this first-degree murder case. Very briefly, witnesses sitting on their porches of their homes on a warm summer evening about 10 o'clock, it was dark out, described seeing a gunman or a man emerge from between two three-deckers.
A gunman that they identified as Jonah or Johnson
was the initial
yes.
identification. But according to these witnesses, this man came out from between two three-deckers into the middle of the street where he fired some 16 rounds of bullets into an oncoming car. The man, according to the witnesses, went back the way he had come, only to reemerge from the other side of the three-decker, where at this point he joined two others in a black Infiniti car.
The reason I interrupted you to say they said his name, they knew this guy. They identified him as someone from the neighborhood. They knew his nickname.
They knew his nickname. They didn't necessarily know his name. And yes, it was shown at trial that the person who ultimately was identified, the defendant John Gomes, did in fact live about 3 or 4 houses
How many
up the hill.
people identified him?
I would say 5, Your Honor.
Okay.
And let me say right now that the trial transcripts certainly show a very close-knit Cape Verdean neighborhood. The witnesses were friends, neighbors, lived in the same three-deckers, and in one case were husband and wife. And as I will make my argument, there is serious reason to find the identification testimony unreliable. But in any event, when this man joined two others in the Infiniti, that car sped backwards up the hill with its lights off. Now, the hill, this took place on Ridgewood Street. Ridgewood Street tees into the intersecting street. Just as it got to the top of the street, the first responders were coming around.
So they get stopped within 10 minutes.
Within 10 minutes.
And there's a different person in the car.
There is a different person named Ken August sitting in the seat the witnesses had said the gunman got into.
Were they backing up the wrong way when the police saw them?
Yes, they would have been, because they had to back into the intersecting street, and that's when the police officers were turning the corner as well, as it's pictured from the transcripts. Now, the police officers, knowing they were on the way to a shooting for, I don't know whether it was a good or bad decision, didn't stop the car at that point, despite its behavior of no lights on and backing up the wrong way. They did put out an all-points bulletin, and they proceeded down the hill to the scene of the shooting. Now, when the car was stopped, as Your Honor says, 10 minutes later, the person in the car was this man named Ken August, who other witnesses identified as having been at the shooting as well. So all of this gave rise to a misidentification case buttressed by third-party culprit. Now, unfortunately for my client, Mr. Gomes, by the time the first witness had been sworn in this case, the prosecutor, through, I say, some egregious misconduct, had devastated his defense of misidentification, and just in case anything was left, the judges in his instructions took care of third-party culprit by telling the jury they were not to consider the possible guilt of anybody else but the defendant. So those are the 3 major issues in my brief, and I'd like to begin by discussing what happened on The View.
Can I ask you one question?
Sure.
Just before you do it? Is Ken August similar in appearance to the defendant, or?
Well, not different, I would say.
Okay.
I think all these young men had, some had braids, some didn't. I'm sorry I can't be
No,
more
that's okay,
explicit.
and it was
Yeah.
not in the briefs. I just was wondering. Go ahead. The View. You were going to talk about The View.
At the behest of both parties, the jury was taken on a view to Ridgewood Street.
Yeah, why didn't the judge go on the view? I read in some brief that because the defendant didn't go, but that doesn't
He
make
gave
any
us his
difference.
reason, the fact that the defendant was not going on the view, and he didn't want the jurors to question the absence of the defendant. I'm not sure I follow the logic,
I think
but
defendants rarely go on views in murder cases.
I know they rarely go on views, and in any event, this judge
And there was no
did not-
objection, I gather, by defense counsel to his failure to go.
No, there was not. And no, there was not. And I guess we just have to say that it was indiscreet on his part. The law does not demand that he go, in Massachusetts anyway. But in any event, the view was taken in broad daylight, and they were, as I say, they went to Ridgewood Street, and now the jurors assembled first on one of the three deckers, where two of the witnesses, or maybe even more of the witnesses, identifying witnesses, had been, and then they moved right next door to the other three-decker, very close, adjacent, to the first floor porch where I think two more identifying witnesses had been. And so now the jurors are assembled where the witnesses were. And the district attorney at this point says to the assembled jurors, I am going to stand in the middle of the street and ask you to take notice of whether or not you can see my physical features from the porch.
And why is that? Why is that wrong to do? I mean, if the defense counsel had wanted to show that the view was obstructed or that the view was so far away that no person could have been able to discern the features that the eyewitness says he or she discerned, why would it not be perfectly appropriate for defense counsel to say, I'm going to now stand here and I'm going to ask if to see what a person reasonably could see from that perspective?
Because, Your Honor, that's beyond the scope of a view. We have a view that the case law describing what a view is about comes out of the common law. It's even codified. It talks about taking the jurors to the place of the crime so they can see where the crime took place. They can see the fence, the wall, the bullet hole.
Okay, so you're saying that if the defense counsel had wanted to show that there was an obstruction or that it was too far away, that the judge should have sustained an objection and barred the defense counsel from doing that on the view?
Well, Judge, I think it gets a little more complicated because certainly the reason for the limitations on a view go to protecting a defendant's constitutional rights. And if you read the case law, and I think it's Daskalakis, but I'm not sure how to pronounce it, in Snyder, when they talk about whether that's evidence, whether what the jurors see on a view is evidence, the courts in those cases say, well, yes, a jury is certainly going to consider that evidence when they are arriving at a verdict. But it is, and this is very important, it is not evidence in the narrow, it is not the taking of evidence such that it would jeopardize the defendant's right to confront witnesses against him. So in other words, that's the reason for not creating evidence on a view, which I contend that that was the vice in this case. Now, in response to Your Honor's question, I would say, well, if defense counsel is going to do that, he, in a sense, is waiving his client's Sixth Amendment right. And that's the best answer I can give you.
And the Sixth Amendment right is the right to confrontation?
Is the right to confront witnesses against them, against the defendant, certainly.
And which witness?
By saying that, the prosecutor turned the jurors into unsworn witnesses.
But that's where the jury's looking at everything around. They're looking to see where things are in perspective.
But from this, Your Honor, by this act, the prosecutor is developing evidence, and this is the crux of our argument. The prosecutor is developing evidence which the defendant cannot meet. The defendant cannot challenge. It's beyond the defendant's ability to challenge what those jurors saw when they looked at the prosecutor's features. how well they could discern the features of someone standing exactly where the gunman had stood.
But doesn't that help them to evaluate the eyewitness testimony by standing where the eyewitness stood?
Not when it can't be challenged by the defendant. I mean, I think and I cite this case in my brief, it's very fundamental in our jurisprudence that what a right to a fair trial means is that a defendant is only going to be convicted on evidence that is heard in a public courtroom from the witness stand under the guidance of a judge who can ensure that the defendant's rights to counsel, to a fair trial, to an unbiased jury, whatever, are protected. That's Turner versus Louisiana. There are a series of cases that treat this issue where I think Turner versus Louisiana itself involved the relationship developing between the two bailiffs who were tending to the jury in sequestration, and by dint of that, the jury's confidence, they were, unfortunately for the defendant, these bailiffs were also the key prosecution witnesses against the defendant.
Well, was there a schematic drawing of the houses in the neighborhood, in the street, that was used either for identification or as an exhibit at trial?
That I don't remember, Your Honor. I've seen sketches as to whether or not
were photographs
yes,
introduced
there were
into
definitely
evidence
photographs
of the house and the
houses
view?
and the street and everything.
Okay,
and that's
so this essentially was cumulative of, if anything, it was cumulative of what was properly admitted in evidence?
Views have been compared to schematics. The purpose of a view is to eliminate the necessity for a great number of schematics and plans. But a view has in mind that what's going to be viewed are generally inanimate objects, uncontroverted. So when you start talking about the features of a prosecutor or features of anyone's, drop down in the middle of this crime scene, I mean, again, all the law describing views talks about taking the jury to the crime scene,
and
describing the essential features of the crime scene.
And why does this rise to the level of a miscarriage of justice? Because there was no objection raised by
There was
anybody.
no objection raised throughout the whole trial, Your Honor. And as I say in my final argument, asking for relief, counsel was denied having any kind of a strong advocate by his side. No, not only was this not objected to, but the cross-examination of the identifying witnesses was pathetic, even to the point of defense counsel referring to the gunman as John. So we have that problem. We also have the problem, or the Commonwealth has, there's also the problem of the third-party culprit. And again, we've got witnesses who are common sense that had to confer with each other. They all didn't make IDs that night or the next day. Some people did not name John Gomes as the gunman until the grand jury. So, it doesn't make sense to say, well, the identification evidence was strong, when in fact the testimony of the identifying witnesses was corroborated by the prosecutor standing in the middle of the street. Of course they could see him. Of course they knew they could recognize anybody standing in the street in broad daylight. Now, and that also is the other problem here, because certainly the witnesses were looking at the gunman in the dark of night with a flashing gun. So the prejudice to the defendant was just outrageous here. And then in the closing argument, the prosecutor gets up and he takes witness by witness and says, okay, to the jury, you stood on the porch at 21 Ridgewood. You stood on the porch at 25 Ridgewood. How could you have not seen that face? So that's what I can say. The prejudice was overwhelming.
No,
Let me ask you this. Had the prosecutor not said, look at my characteristics, and just, they did the view. Would you have a quarrel with the argument, final argument, when he said, well, you were there, you saw the relationship of the houses and the location of the shooter?
Well, he said, that's not what he said. He said, you saw that face. So to that extent, I would, but I would not have the same argument as I'm making here. If he hadn't said anything, if he had remained mute, then I would not have had the argument that what was created was this piece of extraneous evidence.
So then he could have argued to the jury, you were there, these people were sitting on their porches or whatever when they saw this happen. They knew the defendant. He was a neighbor of theirs, well known to them. There's no question that they made a correct identification. You had the opportunity on the view to be in the same position, to see what the distance was in the street from where the shooting took place.
On the surface, that seems, I think that seems different, but the jury doesn't know that the shooting took place at night when they're standing on their porch. And I think there's a difference in saying...
There was no testimony?
Pardon me?
There was no testimony about what time of day or night the shooting occurred?
Oh, yes, I just meant on the view, Your Honor. They knew it by the end of the day, I'll put it that way.
And what time of day did the shooting take place?
10 o'clock at night.
Yeah.
No, the whole point is that
Were there streetlights in the immediate vicinity?
Well, there were streetlights.
Yeah, but streetlights 200 feet up the
Yeah.
road, or were they within 25 feet of the...
I can't answer that question.
Was there any evidence about it? Any testimony about the location of streetlights?
I think they said close by. I'm not sure there was any kind of measurement.
Okay.
Perhaps my brother can correct that, but I don't recall that. But again, the point is that the jurors acquired this extraneous information. And that information was that they could recognize the features of a person standing in the middle of the street. And a class of cases that I call to the court's attention in my brief are those cases where a juror during the course of trial makes an unauthorized view to a crime scene. I cite a New York case where not only the jurors go back to the crime scene on their own, but they reenacted the burglary. We have a Massachusetts case, I believe it's Cuffey, where a juror went back and it was a drug case and there was a surveillance officer and he put himself in the same position as the surveillance officer. The court found reversible error.
Does it matter that he did this in the daylight and asked them to look at his face in the daylight, where it wasn't daylight when this happened? And might that fix in the jurors' minds an idea that the people on the porch got a better view than they actually
Certainly.
did?
That was the problem with the daylight view.
Oh, you mean if the crime had occurred in the daylight?
I'm not saying, but I know that the district attorney has responded and said, well, there are other situations where the court has upheld a daytime view when the event happened at night.
Well, we have to take daytime views in general. We can't ask jurors to come in at night. But it's a different story when you're asking the jurors to get an idea of how the view was in the daytime.
I mean, some defense counsel
incident
would have
happened at
argued
night.
against going on the view at all. You know, I don't, for that reason. So, anyway, as I've said earlier, we have the situation where you've got, four witnesses anyway, swearing that the gunman got into the Infiniti. And not only got into the Infiniti, but there were just two other people in the car. We have three people in the Infiniti. When it backs up to the top of the hill, and when they meet the responding officers, the officers themselves say there were three people. So here is a dilemma for the prosecutor. Either Ken August was the gunman, or he didn't get into that Infiniti.
Did the
Or
juror?
he got out.
He lived
There
near
was the 10-minute window when he could have exited and another person entered.
Well, except when the car was stopped, there were only, another person entered. Yes, Your Honor, but that's
Well,
not
there
what,
could have been 4 people in to begin with.
well, except you've got 4 witnesses saying there were only 3.
He could have been ducking down. Did the identifying witnesses know Mr. August?
Yes, there were two witnesses who didn't necessarily identify John Gomes as the gunman, but who said, oh yeah, that's Ken August, he sells CDs. They knew him from the street.
All right, but did they say that Ken August was the shooter?
No, they said he got into the car. That
Okay.
they saw this person
But
they
the-
knew as Ken August get into the car.
What person they knew? The shooter get into the car?
The person who got into the car was
Okay.
Ken August.
But had they also seen the shooting?
No, they had not.
Okay.
But the point is that didn't give the district attorney the right to say he was going to produce evidence that the car stopped in front of John Gomes's house and he got out.
Your time is up.
And you didn't even answer that question.
Thank you.
Thank you, Your Honor.
Yes, ma'am.
Good morning, Your Honors. May it please the Court, David McGowan for the Commonwealth. With me this morning is ADA Patrick Hagan, who is the trial prosecutor in this case. Commonwealth would ask this Court to affirm the defendant's convictions and also the denial of his motion for new trial. Turn first to the issue.
What do you say to the fact that the prosecutor might have gotten the jurors to get a view of him in the daylight, thereby fixing in their mind the idea that the witnesses got a better view than they really did?
I don't think that was what was accomplished, and certainly wasn't the goal of the view and how the prosecutor handled himself on the view. The purpose of the view is to give the jury an idea or context to help them better understand the evidence that's about to be admitted. In this case, the view occurred before opening arguments.
We don't normally do experiments on views, do we?
No, certainly not, but it was quite...
And aren't experiments considered a class of evidence that generally have to be made under circumstances that were similar to the issue being tried?
Of course. Here...
So why, I mean, if that's true, then wasn't evidence being introduced during the view?
Not in this case, Your Honor. What's occurring in this view and what occurs in every view is...
Was there a judge there to tell them that they had to disregard this? Or?
No, and in this case, immediately after the statement, the defense counsel said nothing to add. And to back to the court's question earlier, the judge decided not to go in the view to avoid prejudice to the defendant. He didn't want the juries to think that the only person out in the view was the defendant, and so to make it not look like he's the sole person not allowed on the view or not going on the view, he elected to stay behind. No one questioned that decision. In hindsight, the defendant certainly complains of that logistical decision.
But typically judges do go on views just for this reason. I don't know, just for this reason, but one good reason is so that if somebody's going to do something that would be better not done, the judge is there to prevent it.
Of course, and it's probably advisable that the judges do go on views, and that's often the reason why they should. In this case, nothing untoward happened. What occurs on views typically is jurors are invited to observe vantage points, distances, observations, exactly, to see the crime scene in 3D and not just as witnesses describe it on the stand. Sometimes it's hard to visualize what they're testifying to. In this case, the view buttressed voluminous witness testimony describing vantage points.
Well, could there have been a reenactment of the crime on the view? Is that permissible?
I wouldn't think so. And in this case, the prosecutor did not stand in the street and say, you're going to hear evidence that the shooter stood here. Can you see my features? A key witness stood where you're standing now. And the prosecutor did not do this on the first floor or the adjoining building at 21 Ridgewood Street, where the witness saw the defendant from 15 feet away. The prosecutor made nothing of a statement of the sort. In fact, the prosecutor, this statement occurred when the jurors were on the third floor of 25 Ridgewood Street, the furthest away from the eyewitness testimony you could see. And there's no evidence to suggest that that was beneficial to the Commonwealth or bolstered the identifications. There's nothing to suggest and that was the clearest view or that it was clear. Jesse asked them to take note of the vantage point. They could have had difficulty seeing the prosecutor's features even in daylight. The evidence at trial also indicated that this was a very well-lit crime scene. There were street lights. All the witnesses testified that it was a clear night, a well-lit night. In addition, the
We would
defendant...
need a well-lit night.
That it was clear, either due to street lights.
How far away were the street lights?
There's no testimony as to distances, but everyone said they could see clearly up and down the street at the time of the shooting. The shooting occurred between 9:30 and 10 at night in late August. So presumably the sun is either going down or on its way down, but there were...
It's on the other side of the world at 10 o'clock at night.
There's no testimony at all on the record as to the degree of the
At 10
sunlight.
o'clock?
There's no testimony of sunlight. Everyone said that it was a well-lit night, either due to streetlights or what. That was not brought out on questioning. In addition, the shooter was illuminated by the headlights of the victim's car. So night versus daylight is not necessarily an important distinction. What was important were the eyewitnesses' ability to perceive, and the purpose of the view accomplished that. In addition, the view also accomplished the jurors to observe what may have changed over time with this view. The defense attorney pointed out a number of times changes in fences, to take a look at how someone would... He didn't argue this, but the purpose was clearly to explain how the shooter would have gotten around to the back of the house and then escape again, given the layout of this neighborhood. The defense attorney also indicated, look up on that street, look where that police officer is on the top of the hill, see how far away that is. In some sense, that's exactly what the prosecutor did. And in both cases, it's innocuous, just having the jury take note of things. This is not just plopping the jury down in a neighborhood and saying, just look around and we're going to have you back on the bus. The purpose of the view is to give context to the evidence and help the jury evaluate the evidence.
Can you explain for me, in addition to the view, did they have photographs of the crime scene, and did they do a schematic, a map or a drawing on a blackboard? Anything?
Yes, my understanding is that there were a number of photos introduced at trial and a number of diagrams. I intended to include one of those diagrams in the Commonwealth's appendix for aid in understanding the testimony. I'm not sure which exhibit number that I was using right in the brief that was, but those were introduced and used during the testimony as the witnesses testified. So the view helped, but it certainly wasn't the only evidence explaining the vantage points and explaining what occurred here, and the witnesses' testimony was very clear. This statement would only go to two witnesses' testimony of identification, Mrs. Alves and her husband, who were on that third-floor porch. It does not go to the clear identification of the Oliveira brothers, who were on the first floor of 21 Ridgewood Street, 15 feet away from the shooter, when 18 shots were fired at the victim's car. This simply, and furthermore, it wasn't mentioned, their ability to perceive the prosecutor's features was not mentioned immediately thereafter in opening statements. It was not reiterated in any form of his questioning of the witnesses, nor was it even alluded to in closing argument. The witnesses were clear in their testimony as to what they saw, and the prosecutor did mention that they're going on the view and understanding the crime scene, but that's all. I think in many cases this is proper. To the degree it was inartful phrasing of what normally occurs on a view, that's all it was. I'll turn to the next issue, an opening statement that my sister raised, that the defendants hopped in the car and was dropped off. That was clearly supported by the evidence. And in addition, when the prosecutor said...
Tell me how that was supported by the evidence. The evidence was that he was not in the car, but what beyond that? He got in the car and then he was not in the car. What's
Indeed.
the evidence that he was dropped off at his house?
Four witnesses identified or explained that the defendant hopped in the black Infiniti that then reversed up the street in the direction of the defendant's apartment. Then one witness, Mrs. Alves, said the car stopped briefly. She did not see anyone get out because it was on the end of the street. She said the distance was too far to see if anyone exited. A police cruiser did come around the corner as the vehicle was reversing on the one-way street. They took note of the license plate and continued on to the crime scene. They then broadcasted that license plate number on the air and then continued to the crime scene. 10 minutes later, this car was stopped and the defendant was not inside it. The inference being the defendant may have been dropped out. It wasn't argued, but he may have been ducking, as Justice Spina noted. But that wasn't an unreasonable suggestion that the evidence would support. Furthermore, immediately after this statement, the prosecutor said, and to the extent that you hear evidence that he walked past the car and didn't get in, the evidence is still clear that the shooter, the killer in this case, was none other than John Gomes. The prosecutor is explaining the roadmap of what he expects the evidence to be in his opening statement. He says there will be evidence that the defendant may have been dropped off in front of his house, He also recognizes that there will be some witnesses that don't testify to that. And he says in that case, it doesn't matter whether he was dropped in front of his house. The evidence is clear who the shooter was in this case. The prosecutor is not misinterpreting the evidence or misrepresenting it to the jury. He's giving them a roadmap of what they're going to hear, and they did in fact hear both those
Do we know
bits
from
of
the
evidence.
evidence when the girlfriend said she saw Mr. Gomes?
There's not immediate time given. She was watching TV at home, but it was that evening. It was not the next day. It was that evening, and the shooting occurred at approximately 10 at night, so not long thereafter.
We don't know how long thereafter.
No, we don't.
It's
No,
just-
we don't.
It was just that same night.
Correct.
Now, I gather in closing he didn't make this argument.
No, it was not brought up at all. Whether he was dropped off or not was not the focus of the case. The evidence, there was a large volume of evidence, in addition to the eyewitnesses identifying the defendant as the shooter, for the prosecutor to focus on, particularly his statements to his girlfriend in person and some of his jail calls, including the consciousness of guilt. That was the focus of closing argument. The defense theory was that this may have been somebody else, and that these 4 eyewitnesses were in cahoots with Mrs. Alves to identify the defendant as the shooter because she had some motive against the defendant. Whether he was dropped off or not simply was not a focus of this case in any significant manner.
Now, if I could turn briefly to the fracture match of the electrical tape. The expert, I gather, testified that each tape fracture is unique.
Correct.
Is that supported by the scientific evidence that there are no 2 tape fractures which are the same?
Yes. What the criminalist explained was that every time you tear a piece of electrical tape, it would create a different jagged edge or jigsaw puzzle-like tear that would then be compared to see if there was a match. And what she did, she looked at all these pieces of tape and then lined them up, and they did in fact fit like a jigsaw puzzle. And what the jurors were able to see, in addition to the pieces of tape themselves, was magnified images of these pieces of tape. These photos were entered in as exhibits, and it did look like a jigsaw puzzle. They were perfect fits.
So have there been studies where 10,000 pieces of tape were ripped and none of them ever looked alike? I mean, some scientific basis for the conclusion that this is a unique tear once it's torn? I'm just curious, because it might say, yeah, it looks really like it, and here's why.
The prosecutor included some literature in his motion to admit this testimony, his motion to eliminate. This was not litigated in terms of the reliability. Had that been the case, more evidence for and against this type of testimony could have been introduced. What the criminalist did explain to the court and to the jury was that this has been accepted for decades within forensic science. It's not a specialized analysis of some other types that do require consistent reevaluation in the courts and in trials. This is something that she explained was been recognized for decades. It's the foundational introductory part of her forensic science of plastic, glass, a number of different substances. How do you put them together? She explained at length what a fracture match was and how it's created and how she analyzed it. This was not some incredibly complex issue of scientific evidence at all. And after this lengthy explanation of how she went about evaluating this bit of evidence, the jury was given the evidence, and I would suggest at that point they were in just as good a shape to evaluate this evidence as the criminalist following this testimony heard.
Now this tape, this was the tape that was wrapped around the gun, the butt of the gun?
That held the Crown Royal bag that collected the cartridges as they were ejected.
Uh-huh.
Yes. And so the Commonwealth's theory was that John Gomes put the Crown Royal bag on there, and that's how they connected the tape in his apartment to the tape on the murder weapon.
But it didn't work, apparently. There were 15 bullets, weren't there?
I believe there were 18 shots fired. Eight struck the victim and killed the victim. I'm not sure if it collected. I believe Your Honor is right that there were only 15 cartridges in the bag itself, so some may have not have been retained by this bag. There is no evidence to attest to see whether that would work or not as a catch bag. or whether it worked perfectly. It certainly caught a significant amount of the shots that were fired that night.
Now, what do we do about the fact that there was a motion in limine to offer this fracture match? According to the docket, I guess it was denied.
Indeed, the docket indicates that on September 18th that motion was denied. That was the same morning, well into the trial, that Ms. Zilikowski testified to this evidence. There's no mention in the transcript at all of this being discussed that morning. A number of other motions were discussed before the court. I don't know whether that was a mistake or what. Presumably, even if it wasn't caught on the recording equipment, had this been denied and defense counsel had been aware of it, he would have been objecting, I would imagine, quite ferociously to keep this evidence out. The defendant never, throughout the trial, and this is indicated in an earlier conversation between the parties, he never challenged this evidence on a reliability grounds. His hope was to use this evidence to attack its chain of custody, and to do so to also attack the credibility of one officer in the chain of custody that may have had some issues and try to impeach the investigation from that angle. And he did attempt that and succeeded to some extent on trying to show that the tape itself was not really useful testimony. And in closing, he did identify that this evidence is only useful, it's just tape from the eyes of a microscope. He diminished this. I think it points out the simplicity of the evidence. He tried to diminish it in the sense that this is simple, common sense evidence the jury could expect. Had the judge decided not to allow the criminalist to say her opinion of whether or not the piece came from the roll, she certainly would have been able to put, here's the piece from the roll under a microscope, here's the piece that was recovered from the gun. The jury could have lined them up themselves.
And the jury had the blown-up photographs?
Correct. Both the pieces of tape themselves, photographs of the pieces of tape laid out, and then the photos were taken under the microscope, so they were able to do this themselves. And those were trial exhibits. If Your Honors have no further questions on any of the other issues, thank you, Your Honors.
All right. Here you